the European Court would have exceeded the task of a mere interpretation of Article 54 of the treaty. And in my view, it would have acted more like a legislator than like a judge. I think that the European Court seems to be building a kind of conflict of law system in company law, but not, of course, from jurisprudential origin, not legislative one. That is to say, the court has not limited itself to say, well, member states must recognize the companies formed in accordance with the law of another member states, because this is a consequence of freedom of establishment. Okay, but it has gone further than that. In the rulings that have followed Centros, for example, mainly Universitat and mainly Inspired Art, the court has said, for instance, that take the example of the Inspired Art ruling of 2003. It said that the liability of directors of the company should be governed by the law of the state of incorporation of the company. Well, of course, this is a possible solution, and in many member states, it's like that. But this is not the only possible solution. And in any case, what we can say is that an assertion of this kind exceeds clearly what would be a mere function of interpreting Article 54. So it seems that the court would be acting not really like a court, but more like a legislator. To sum up and to demonstrate a little bit this argument, I would like to, let's say, to present what would be the content of this conflict of laws regime that is being developed or built by the court. Also, one of the works also in this research project by the colleague I mentioned before, Rafael Arenas, he even tried to codify the content of this conflict of laws rules in company law. It would be the following. Very basic features would be the following. First of all, the legal personality of companies formed in accordance with the law of a member state must be recognized in other member states, and this would allow them, for example, to bring legal proceedings in other member states and to set up branches also in other member states. That would be Centros Universitat. Secondly, and this we can see in Universitat and Inspired. The personal law of the company, the so-called lex societatis, would be the law of the country in which it is incorporated or registered. Therefore, the court seems to adhere here to the so-called incorporation model in international company law, and to set aside the opposite model, the so-called real seat model in company law. And thirdly, this law would govern the legal capacity of the company, including the capacity of being a party in legal proceedings, the requirements as to minimum capital, and also the liability of directors. These two aspects, these two last aspects, this was said in Inspired.